Taking the High Road podcast, presented to you by Divorce Buddy and CDC Certified Divorce Coach. Welcome to the show. In the Taking the High Road podcast, you'll learn simple strategies for creating a healthy divorce no matter what stage you are at. This podcast also has a companion book available from Amazon.com that includes valuable insights from 11 certified divorce coaches. To learn more, be sure to visit highroadanddivorce.com. Again, that's highroadanddivorce.com. On today's episode, we're going to be talking to Kurt Chacon. Kurt is a Texas attorney who practices collaborative divorce. He's also a CDC Certified Divorce Coach. We're going to touch on some key concepts. Firstly, why collaborative divorce is a much better way of reaching an agreement with your spouse. Also, how collaborative divorce is interest-based and client-centered. Kurt will also talk about how collaborative divorce isn't necessarily easy. It's not necessarily the least expensive, but it is about reaching an acceptable agreement for both parties, and it's about the future, not the past. So with that, I would like to welcome Kurt to the show. Hi, Kurt. How are you doing today? Welcome to the program.
Glad to be here, Jeremy. How are you today?
I'm doing great. Now, Kurt, let me ask you, you've got a unique background in that you've experienced family court as a family law attorney and as a parent going through divorce, and as a divorce coach for the last 5 years, and also as a collaborative law attorney. Now, given that litigation can be so profitable, what inspired you to get into this field as a collaborative law attorney and coach rather than be a traditional family law attorney?
I'll tell you, basically, it was my experience both as a parent in divorce and as a child of divorce. My parents got divorced in the 1970s. Back then, very few people got divorced, so divorce was never seen as a problem. Behavior of parents and the wrangling that took place in the legal system was not seen as a problem because not that many people got divorced, and certainly no one talked about it. My experience as a child going through divorce it wasn't a good one. I'll just say that. And so when I came to the point, regrettably, in my life where I was going to be divorced as a husband and father, I wanted to try and do something differently that would minimize the impact of my children. And so I was able to choose collaborative divorce as a husband and father. And through that process, hired a couple of lawyers that said they did collaborative work, but really weren't committed to the process. And I realized that that's something that I needed to do going forward. I needed to get trained, and I needed to bring a commitment and skill level to that so that children of divorce, the parents have an option of choosing something that's going to minimize the impact of divorce on their children.
Now, how did some of these experiences, these childhood experiences and other experiences really shape your outlook on the whole divorce process?
Well, first of all, the effect of divorce going back to the 70s, it affected me. It affected my life. Children mirror what they see in their parents, for good or bad, for right or wrong. And what I experienced was pretty much the worst of the worst. I won't go into detail, but my parents continued to argue, continued to be upset, continued to fight, continued to alienate each other for years to come. And that affected me and my life. They weren't very good role models as a husband and a wife. And so at the time my divorce was imminent, so to speak, I had to sit back and say, okay, I'm going to choose something different going forward. I'm going to choose more cooperation. I'm going to choose forgiveness. I'm going to choose to let the past go. And not only did I have a different divorce than my parents did, it affected me being able to put a lot of that stuff in the past, from my past, in the past, and move forward in a different way in my life, not only in the divorce, but in my life as well.
Now, a lot of people have these preconceived notions about the divorce process. They believe that they have to hire an attorney and go to family court and go through the family court system. So can you describe what the differences are between the collaborative law process and the more common litigious process?
Yes, I can do that. First of all, everybody who gets a divorce, regardless of what process they choose, has to request that the court grant a divorce. And at some point, someone has to go down and say the magic words in front of a judge, and the judge says, okay, you're divorced, and the judge signs his or her name to the decree, and that's your divorce. Everything that happens between the initial filing of the case and the signing of the decree, that can be completely different depending upon the process you choose. In the collaborative process, nothing happens in court. Everything is done by the agreement of the parties. It's private. All the discovery, that is the exchange of information, takes place simply by request. In other words, if one party asks for something, the other party produces that document or thing or item, because the building of trust is important in the collaborative process. Everything that happens with the parties pretty much sitting in the same room, talking to each other, exploring options. You have other professionals, whether it be lawyers or financial professionals or mental health professionals, in the room at these meetings, helping shape the interests of the parties, the goals of the parties, helping understand the current situation of the marriage, the finances, the children, and so forth, coming up with options, and then measuring those options versus the interest and goals that the parties had in the beginning, and eventually at these meetings coming to an agreement that gets written up by one of the lawyers, and the parties have an opportunity to look it over, take a little time, and then agree to it. Then at the end, somebody goes down and gets the judge to sign it. It all happens outside of court. And I will say one other thing, that if any time any client wants to go into litigation, they can leave the collaborative process behind, opt out of that, and opt into litigation. A very significant difference is the lawyers who've been representing the clients in the collaborative process must withdraw, and the parties must employ new lawyers going forward. That takes away the incentive of the lawyers in the collaborative process to milk the process, then move to litigation and continue to milk that. The incentive is for the lawyers to keep the clients in the process and finish it there. That's a significant difference.
That's a great point, Kurt, and I think it's a point that a lot of people don't really consider. You know, also in terms of building that trust, that exchange of information is much different with the litigious process, where discovery can almost be like a form of harassment, right? Just like give me all this, you know, like they're asking for things, hard drives and anything that you can think of, just to try to be more strategic rather than, you know, more adversarial, rather than trust building and creating a collaborative environment.
I agree with that. And, you know, one of the things is that since 95% estimated of all divorce litigation settles out of court, and just so people understand, a settlement out of court is an agreement, okay? It's an agreement. All of that information that you just described has to be produced in a way that will allow it to be admissible at a trial that's probably never going to happen, right? 95% chance that all the time and money that the parties have spent collecting this evidence in an admissible form will never be admitted to a court anywhere, and they have paid what I like to call the litigation premium for that, versus simply coming to the table with all of their financial information and exchanging it and getting a complete crystal clear picture of where the parties are and moving forward from there. You can spend 20 or 30 times that much doing that in litigation for a trial that's basically never going to happen.
Right. And with 95% of divorces ultimately being settled, why start from the beginning in an adversarial context? It really doesn't make any sense.
Well, I agree with that. And some lawyers will say, well, and you pretty much have to be sort of in agreement to go through the collaborative process. And people hear the word collaborative, and that's what they think. We pretty much have to agree. No, you don't have to agree. It's all in how you come to an agreement. If you choose litigation, you're going to agree. And generally, that's going to be right on the courthouse steps before a judge takes what I like to call the meat cleaver of justice to your family and your estate, right? Or you can work through it sitting across the table from the only other person who cares about your children as much as you do, in front of the only other person who knows the family as well as you do, and you can make any and all decisions sitting across the table from your spouse rather than allowing, risking the judge doing it. And that's how settlements are done. Well, if we don't take this today, the court may rule against us, and everybody gets all excited right at the end. When in the collaborative process, you can take your time.
Right. Those are great points. And you've really underscored a lot of the benefits of collaborative law. Now, maybe just crystallize or summarize what you see as the key benefits, the key advantages of collaborative law, and the collaborative law or collaborative divorce process versus litigation.
All right. First of all, collaborative divorce will never be sitting down at the kitchen table and coming to an agreement with your spouse. However, it will be cheaper than litigation, first of all. Second, you keep everything private since you don't go to court. Third, the lawyers are there and their incentive is to get you to an agreement. Everything is done by agreement and you build trust. Allegations are not made simply for the sake of leverage. Mental health professionals and financial professionals in the collaborative process are neutral. They give you objective, neutral advice as you move forward. The collaborative process is not about the past. It's about the present and the future. It helps people move away from what happened, 5 years ago, 10 years ago, moving forward to their new life. The collaborative process puts the two people who know the family best in charge of what happens. That to me is significant. And if you have children and you are concerned about the impact of divorce on your children, doing a collaborative divorce gives you the best chance to minimize that impact and walk away with a cooperative, cordial, supportive, co-parenting relationship that will affect your children in a positive way going forward. It's not a guarantee. It just gives you a much better chance of doing that.
Right, and I can just imagine in terms of because it's a cooperative and collaborative process where an agreement's not forced down your throat. You have time to review it. The compliance is going to be a lot higher, and the likelihood of going to court, having to go to court again and again to solve every single dispute is going to be lessened significantly.
I like the way you said that. It makes your chances of ongoing cooperation much more likely. It's not a guarantee. It's much more likely. And having to sit across the table from your spouse and talk about options and agreements and so forth is a lot different than having your lawyer call their lawyer up and have a settlement negotiation where people don't have to see each other and can, how can I say this, use lawyers as some sort of go-between. And it's much easier to be difficult and obstinate and angry when you use them like that than sitting across the table from your spouse.
Right, exactly. Because when you lose the discourse, now you're relying on fighting through proxies.
Right, and the proxies sometimes don't get along. Sometimes the lawyers don't get along. Sometimes the lawyers and the judge don't get along. I call it taking back the reins. At some point, sometimes the parties need to be in control. Take back the reins from the judicial system and the lawyers and make it client-focused rather than judicially focused.
Yeah, great points on all fronts. Now, the terms collaborative divorce and mediation, they're both often misunderstood, and sometimes people think they're the same. Now, you have these different aspects. The collaborative process is one thing. Can you just briefly explain what the difference is between collaborative divorce and mediation?
Mediation is sometimes used in the collaborative process to help clients get unstuck on a particular issue. But generally, mediation is considered part of the litigation process. At some point, the judge will order mediation. A mediator is someone who is trained in dispute resolution. Many times in the family law courts, mediators have some experience, some depth of experience in family law. parties meet, the mediator goes back and forth between rooms with potential settlement offers. They're skilled at getting clients to talk about what it is they want and why. The mediator sometimes points out where a client is being unrealistic versus what the court might do in the hopes of getting people to get to a real point of agreement. All right. And they go back and forth. And a lot of times as the day wears on, people's nerves fray. Each lawyer's charging $500 an hour. You have a mediator charging $250 an hour, and you've been there 8 hours, and that's 10 grand, right? Okay. Well, people get really anxious about an agreement, and a lot of times it's forced upon them at the end. It is an agreement created by lawyers, and it is approved by the clients. In the collaborative process, there's no time pressure. We move at a much slower pace, giving everyone the opportunity to come to some agreements, think about them, tweak them, and move forward. Collaborative agreements are agreements that are created by clients and approved by the lawyers. The lawyers are there to make sure that what the clients agree to can manifest itself in reality when the divorce is final. You want this to happen, we have to have this structure in place. You want that to happen, we have to have these things in place to make sure it gets done and it's legal. And if it isn't done, we have recourse. The collaborative process allows the clients to be in control. The mediated process, it is a very different process when used in the context of family law.
Now, also within collaborative law, we hear the terms interest-based negotiation, client-centered process. Now, what exactly do these terms mean?
Well, for client-centered means the clients control the pace of what happens. In the collaborative process, since everything takes place out of court and most everything takes place at client meetings, the clients can go at a pace that works for them. They can go much faster than things might go in court, or they can go a bit more slowly, or whatever works for them. So it's client-centered. When you're in litigation, it's centered by the court's calendar and the calendar of the lawyers. Yes, occasionally a client might get asked about a date, but everything is going according to the court's calendar and when the lawyers can be there. That doesn't happen in collaborative law. That's what I call being client-centered versus judicially centered. Interest-based negotiation versus position-based. In position-based, you're going out there to get what you're entitled to. I'm entitled to half. I'm entitled to this. I'm entitled to that. Interest-based means uncovering what the parties really want and seeing if both people can get what they want. Many times, clients are interested in minimizing the impact of divorce on their children and maximizing the amount of time they get to spend with them. Well, a lot of times, those are common interests. So immediately, people can find common ground. That's not what happens in litigation. Lawyers are really not trained to ask you what it is you really want. Lawyers are trained to get you what you're entitled to. And so interest-based negotiation is more win-win. Position-based negotiation is I win, you lose.
Those are great points. You're exactly right. It's win-win versus win-lose. Now, you've touched on this before, but I think it warrants going into more detail. As far as clients needing to be, or the misconception that clients need to be agreeable before they go through the process, now you say that's not necessarily the case. So maybe you can just expound a little bit on where they can come from, basically, before they enter that process, and whether they really do need to be agreeable before they even start the process.
I will say that since the clients will be sitting in the same room, that at least they need to be able to be civil to each other, okay? And they need to be able to have open and honest communication. That's what the team around them is for. The lawyers, the mental health professional, the financial professional, the neutrals, as I call them. The lawyers are advocates. The others are neutrals. They do not have a relationship with a particular client. They do not take a particular stand for what a client hopes to gain. And in that process, they come to an agreement in a different way. In the collaborative process, anything and everything that might solve the problems are available. In litigation, the solutions that people come to in litigation are generally focused on what the court will and won't do. All right. And what ends up happening is right at the end, somebody comes to a settlement right at the very end. And it's almost totally linked to standard visitation and a split down the middle, right? That's generally what it comes down to. How much visitation, how much child support, and a split down the middle. The collaborative process is completely different than that. In the end, everybody comes to an agreement. It's just a way of taking the reins back from the courts and the lawyers and keeping the decision-making process and the pace of that in control of the two people who know the marriage and the children best, and that are the spouses. That is the spouses.
Right, and I think it's a bit funny, too, as far as the misconception about being agreeable ahead of time, because if you think about the litigious process, like family court, is that going to make you more agreeable or less agreeable?
Exactly. It doesn't necessarily make you more agreeable, but I can tell you this, that process can poison the well going forward for a relationship between the parties, especially if they have children. That nobody wants to show up at a sports game because of anger and resentment. Gosh forbid somebody show up at a sports game with a new relationship interest during the litigation process. Then going forward, holidays, graduations, weddings, all the stuff that we as parents continue to be involved in with our children and their lives going forward, you can either have it be really nice or you can have it be really bad. And how you choose to come to an agreement can affect that going forward until whoever passes away first.
Yeah, and that's a huge point that can't be emphasized enough, is that you had mentioned the privacy involved. This is a private and collaborative process where we're trying to cooperate, whereas in an adversarial process like family court, it can get really nasty, potentially nasty allegations that can be introduced, and that's damage that's created, resentment that can really breed further animosity, and it's hard to take back. You can start in collaboration or a collaborative process and then go to litigation under the worst case scenario. But once you plant your feet in the ground and you've already started from an adversarial posture, it's a lot harder to undo a lot of the damage that's already been done. Would you agree with that?
I would agree with that. Now, sometimes that can be done by the personalities between the lawyers and the judge. And sometimes we have had cases in which people have opted into the collaborative process and out of litigation. And in the minute the parties took back the reins of communication, the case settled. But you're exactly right. The allegations that are sometimes made and how they're made and how they are received by the parties can make people bitter going forward. Research has been done. People have been interviewed 10, 15 years after their divorce in which they got a good deal, and they're not happy. And the reason they're not happy is because of the process. And the reason they're not happy also is because they may have gotten a good deal from a lawyer's point of view. They did not get a good deal from their own point of view because no one sat down with them and explored really what they were interested in and really what was most important to them. And in litigation, I've had people come in and say, I want to minimize the impact of divorce on my children, and turn right around and say, I don't want my spouse to get a dime. I want all the money. As far as I'm concerned, they can live in a one-bedroom apartment and drive a Ford Pinto. And sometimes you have to sit back and scratch your head and go, well, okay, how exactly does that minimize the impact of divorce on their children if they feel like one of their parents is broke and a deadbeat? Right?
Right.
And in the collaborative process, if you say you want to minimize the impact of divorce on your children, everything that's proposed and all the behaviors in the process, okay, how does that square with what you said? Is that furthering that, or is that working against that? No lawyers ever ask that question in litigation. We do in the collaborative process.
Now, in the family court process, within family law, it's really actually, okay, as an attorney, I don't really care about that. Conflict's great, right? Because I'm making more money. So they don't have that same incentive to minimize the conflict.
And people need to understand that. The collaborative process, lack of conflict and resolution is what lawyers want. They don't have an incentive to milk that process and then jump into litigation because they can't profit from it. That's huge.
Now, what would you say are some of the most common obstacles or misconceptions that people face when they're considering divorce? And what are their most common concerns?
I think one of the misconceptions is that they will be heard by the judge, they will be understood by the judge, and the judge will make a just and fair decision as they see it. Okay? 95% of the cases never go to court. And I can promise you, if you read interviews and research done on people who eventually do go to an actual trial, you will see that is this idea that the judge is this, wise Solomon at the end and will see through what people perceive to be the lies and the manipulations of their spouse and get to the true heart of the matter is simply not true. And I don't mean that judges are bad people. I'm just saying that the reality of the legal process is not what you think it is. People think that their lawyer will work closely with them and they'll have this great relationship and their lawyer will understand them and they'll work together to solve this problem. Again, that's really not true. It can happen and it might happen, but generally a lot of times it doesn't. Another misconception is people think they are joining a client-centered process and they don't realize they're not the boss of anything. The court and the lawyers control everything. And a lot of people can't get on board with the process they've chosen. They choose this process not really knowing they're not in control of anything except, yes, I'll take that, no, I won't.
Right, and also going to your first point, they often confuse legal justice with fairness.
Exactly. Let me tell you, you go down for a hearing for temporary orders. We're going to say, okay, what are we going to put in place in terms of child support and visitation and income and all that stuff before we can get to a point where we can get a trial or settle this? In Dallas County, brother, you got 20 minutes aside. You don't get to have a half a day before the judge. You get 20 minutes for the judge to hear your plea for justice. And if you're having a bad day for whatever reason, guess what? That might be the last time you see that judge and you had a bad day.
Now, clearly, there's so many benefits in terms of the collaborative divorce process. Why do you think it is that collaborative divorce isn't more common or more popular?
First of all, I don't think people know about it. Second of all, if they do ask a lawyer about it and the lawyer is not a skilled practitioner of it, one of two things will happen. That lawyer will either say, it's not right for you, or they will say, sure, I'll take your case, and then butcher it because they're not committed to the process. Okay? Many times, some lawyers won't even tell a client about it. There's a huge debate whether or not a client comes into a lawyer's office and talks about divorce and says, okay, what are my options? The question, does that lawyer say, well, you have traditional litigation, you have collaborative divorce, you have we could do some sort of mediation, outline some options for them, whether or not they're required to say anything other than I'll file your divorce case with you and maybe we'll get a mediator down the road, whether or not that's required by the ethical rules. Okay, there's some question. And if a lawyer doesn't think that he or she can handle a collaborative case, there's a good chance they won't even tell a client about it, the collaborative process. Why would they let that walk out the door? Circles back around to the idea that lawyers are going to do what's in their best interest. Divorce is a $60 billion a year industry in this country. There's a lot there, and lawyers want their part of it.
Yeah, it seems odd that we essentially created this a model, an adversarial model for families going through a very stressful time in their lives, where there's already a lot of tension, and we're just exacerbating that. And that's the default process for families.
Yes, if you look at the family code in Texas, for instance, in the 1950s, and the amount of pages and the number of words versus what it is now, I'll tell you this, every time something is added to the family code, another provision, another attempt by the legislature to solve a problem, all that means is one more thing for people to argue over and one more thing for lawyers to get paid to argue about.
Right. It's as if they solved one problem, but the law of unintended consequences, they created far more problems.
Right. Now people want to litigate that issue too.
Right, exactly. Now, are there any couples that you'd say are not necessarily good candidates for the collaborative process and would actually be better suited for the traditional approach?
I will say this, that there are some cases where perhaps the weight and gravity of the judge and the legal system might be of benefit if there is such a huge disparity in the bargaining power of the couple. Perhaps traditional litigation might be better because they can't be in the same room and be considered on the same level, if that makes sense. There are those, and finally, there are people who are so bitter. I tell people, collaborative divorce is not the past, because if one wants to seek retribution and revenge, collaborative divorce is about the present and the future. It's not the past. Maybe if that's what you want to do, then you need to go to litigation. That's going to serve you, at least in the short term. You won't ever find what you're looking for, even in litigation, in terms of the actual outcome being revenge or retribution. But the process, as you described, how you act in litigation can certainly give somebody, what they want. They can be an insensitive, uncooperative, uncommunicative, and unreasonable jerk and play that out to the hilt in litigation.
Now, I guess the counter to that argument is that if there is such a power imbalance, let's say one of the parties has a cluster B personality disorder, borderline personality, or let's say, for example, a narcissistic husband who made all the money.
Right.
And the adversarial process of family court just magnifies that power imbalance. So that party is going to really leverage those attorneys and fight it until the bitter end.
It certainly can. I mean, a lot of times, the spouse that didn't make the money has to go to court to seek to get attorney's fees paid. And, it's just really crazy. But there are some people for whom that's the only way that it's ever going to work. But with a good team of lawyers and professionals around both parties, a lot of great results can happen even when going in the parties seem very far apart. I tell people it's not easy. And the reason it's not easy is because, like you said, you don't talk through proxies. You can't throw it in the lap of the judge later on. You have to sit across from your spouse and make a decision. That's not the easy part. The great part is you two are the ones making the decision. It's not about the past. It's about the future and who you're going to be going forward and whether or not you're going to be a good pair of co-parents for your children and present some kind of behavior that your children can model with satisfaction in the future. Okay? I tell people it's not about the cost, because it's always cheaper to sit down, come to an agreement at the kitchen table, have one party get one lawyer to draw up your agreement, then go to the courthouse and prove it up. It'll never be cheaper than that, but it will be much less expensive than litigation. And I tell people collaborative divorce is not about what's fair. It's about what's acceptable. And in the end, since no one is, like you had said before, forcing you to take an agreement, nobody's telling you this is a good deal, you really need to take this. In the end, that agreement is one that you chose freely to make and it was acceptable to you. There are times when I look at mine and I have to realize that's an agreement that I chose. Nobody forced me to do it. There was not a judge threatening me, that he was going to decide something. There was no mediator pressuring me. My lawyer was not pressuring me. I chose that agreement. It was acceptable. And I look at it and I go, okay, I'm good with that.
So in general, not just in high conflict divorce, but in any sort of case, clearly it's important that you hire the right professional. So maybe you can go into exactly what sort of criteria a person should use, or a couple should use, a divorcing couple use to evaluate and select a collaborative law attorney or collaborative team.
I would say three things. One, their experience in the collaborative process. There are a lot of lawyers who've done their own collaborative divorce and they, like myself, understand what a client goes through. Second, you want to know how much training a lawyer has had in collaborative processes and collaborative theory. You can examine that. You can ask them. They probably have a bio. You want somebody who's actually done the training and understands the process. And finally, commitment. Even though a lawyer may have handled some cases and maybe had some training, that's not what they embrace. They are not really committed to the process. It is simply another revenue stream or product line. So experience, training, and commitment, the three keys to choosing your collaborative lawyer.
Well, thanks so much, Kurt. Really enjoyed the conversation. You offered some really great perspectives. So in closing, how can the listener learn more about you and learn about your practice?
Anyone can contact me at my website, divorcedifferently.org. That is my website, collaborative family practice, as well as divorce coaching. You can contact me there, or my number, 214-533-2634. In terms of coaching, I'll offer anyone who calls a free exploratory session and have a conversation with you about your divorce, what you're thinking, and discuss the possibility of how I can help you or how I can find someone who can.
Excellent. Thanks again, Kurt. Really appreciated the time.
Appreciate it, Jeremy. Thank you.
Thank you for joining us today on the Taking the High Road podcast. Be sure to stay tuned for the next episode. And if you're interested in learning more about the companion book available from Amazon, visit highroadindivorce.com. Again, that's highroadindivorce.com. Thanks again.